The United Nations has found New Zealand breached the Convention Against Torture by failing to properly investigate abuse at Lake Alice Hospital in the 1970s. A victim took the case to the UN because the psychiatrist accused of electrocuting patients as punishment has never faced charges.
Paul says in 1974 he was diagnosed with a behavioural disorder by psychiatrist Selwyn Leeks, who he claims then tortured him.
They have you sitting in the chair or they have you laying on the bed. Nurse is holding you down, you've got no choice.
Repeated attempts to contact Leeks, who now lives in Australia, have been unsuccessful, but he's always denied wrongdoing.
Do you apologise for anything?
No, I don't think I do.
No matter what the government officials say, torture on the testicles is pretty serious.
We are the revolution. We want it all tonight. We want to take back what's rightfully ours. We are the
Good morning everyone, Mark here. Hope you're all happy and having a great dandy day. There's a bit of sunshine out there this morning, so yeah, awesome. I've just finished watching Pat's live broadcast, Police Abusing Powers over in England. Dan, mate, you're a top bloke. So yeah, people have been going on to me about this torture case and that I didn't have proof and all the rest. Now, we've seen a couple of clips now on stuff.co.nz or TV3.
This week, the United Nations will look into the alleged abuse of children at Lake Alice Hospital in the 1970s. Specifically, why disgraced doctor Selwyn Leeks has never been brought to justice. 40 years on, the victims are still asking for a court trial. Is our government persisting in putting its reputation first? Here's Mike Wesley-Smith.
It's a case like no other.
Where would he apply the electrodes?
But the genitals was his favourite spot.
Have you listened to their stories? Is there any truth to them? Truth?
It's a matter of national shame.
Let justice take its course.
And right up to this present day, he's just destroyed me.
A paper trail of allegations dating back 40 years.
Last time I would have read this was probably back when I made it.
Charlie Symes is reading the statement he gave to a patient rights group when he was just 15, alleging psychiatrist Selwyn Leeks shocked his genitals at Lake Alice Hospital.
Which is just straight pain.
For a kid, it was a scary place, scary people.
Marty Brandt is another patient of Dr. Leeks. Like Charlie, a tough man, once a terrified teen.
He applied shock treatment to my genitals, left with permanent burn marks on the underside of my penis.
In the end, it just wasn't worth saying a damn thing. We just sort of suffered in silence.
Kevin Banks was only 14 when he arrived at Lake Alice, where he too says Leeks shocked his testicles.
Still to this day, I'm 60 now, I still can't get over it.
Kevin says Leeks also asked him if he'd like to shock another child, a scene captured in these drawings by fellow patient Bruce Harkness.
We were offered the availability if we wanted to electrocute him ourselves. I declined the offer. It was something I didn't wish on anybody.
I actually saw Dr. Leeks put the electrodes on the genital area.
And he started screaming out loud in agony.
Leeks has called these claims completely untrue. But according to the United Nations, more than 200 acts of ill treatment and torture happened here, the site of the old Lake Alice Psychiatric Hospital in rural Wanganui.
Do you apologise for anything?
No, I don't think I do.
I think he went too far. I think he got carried away with his own sadism, his own cruelty, and didn't recognise it.
Former nurse Brian Stabb worked at Lake Alice.
It's had its own rules, its own staff, and it's very secretive. Leeks would have known that what he was doing was over the top.
Brian says Leeks gave electric shocks to children without anaesthetic or consent. The UN says this can constitute torture.
It's effective, it's quick, it's life-saving.
That was assaultive. From the moment the kid was told he was having ECT, dragged up the stairs, and he fought and resisted.
We've made extensive efforts to contact Selwyn Leeks without success.
Are you ashamed by anything you've done?
No.
Following complaints from children in the 1970s, medical authorities cleared Leakes of wrongdoing, and he moved to Australia in 1978. In 2001, Kevin gave an interview to the 2020 program.
I believe he'll always have in his heart this evilness.
Along with 90 more of Leakes' former patients, in 1999 he filed a class action against the government with lawyer Grant Cameron, and they were awarded millions in a compensation settlement.
Generally speaking, did you think there was enough evidence to lay a criminal prosecution?
Absolutely.
Bolstered by their win, Kevin and 54 other patients sent written complaints to police in the early 2000s, hoping Leakes himself would finally be brought to justice. Assistant Police Commissioner Malcolm Burgess headed the police investigation.
We'll make an assessment on whether a prosecution is possible or not.
A child psychiatrist told police Leakes' treatments were often very poor or inappropriate.
It is unacceptable. And in these circumstances, it's assault, it's grievous bodily harm.
But to patients, the police investigation seemed half-hearted. Only one of the 55 complainants was interviewed.
No, I never saw the police at all.
Yes, it probably does have a lower priority than current matters.
An opinion provided to police by the Crown Law Office dismissed Kevin's complaint as a medico-legal issue. The Crown Law Office are the government's lawyers. Kevin now wants to know why police got advice from Crown Law on prosecuting Dr. Leakes. It's because, unbeknownst to him, between 1994 and 2002, Crown Law defended the government against claims of abuse made by other patients against Dr. Leakes, cases that were eventually settled. That meant the allegations were never tested in court. Gillian Kincaid is a former prosecutor.
There appears to be what at best can be described as a conflict of interest.
While they were defending the actions of Leakes in court, Crown Law investigators obtained 38 witness statements from former Lake Alice staff members. When New Sub Nation asked Crown Law if those statements disclosed any criminal offending, they refused to tell us, citing professional privilege. Crucially, Crown Law did not tell police of the existence of those staff statements. Instead, they advised detectives there was insufficient evidence to charge Leakes. To this day, the contents of those statements, including whether or not they contain evidence of crimes, remains secret. Earlier this year, Crown Law opposed our attempts to see evidence given by Dr. Leakes in the earlier court cases that were defended by the government. But the court let us see it, and for the first time we can reveal that Leakes left for Australia with the full backing of the New Zealand medical establishment. In his evidence, Leakes said the Medical Council gave him a certificate of good standing. And the Royal Australian and New Zealand College of Psychiatrists offered Leakes the directorship of a child psychiatric unit in Melbourne.
To recommend him so that he could carry on practicing in Australia is also disgraceful. It's a disgrace. It's a matter of national shame.
But in 2006, Leakes' past finally caught up with him. Australian medical authorities brought 39 disciplinary charges against him, and Leakes agreed to retire. But back in New Zealand, the police still refuse to file charges.
And right up to this present day, he's just destroyed me.
We asked retired detective Dave Pizzini to consider the evidence.
We were talking about sustained and systematic physical and sexual abuse of children. The fact that none of those perpetrators have been held to account in the criminal courts is reprehensible.
We can reveal two former senior detectives who worked on the Lake Alice investigation in the 2000s have told us they believe that Leakes should be prosecuted and that a huge injustice has occurred. We have also obtained this 2006 job sheet from Malcolm Burgess of an interview he did with a former Lake Alice nurse. The nurse said he saw Leakes apply the electrodes to the genitals and thighs of a boy in the child and adolescent unit.
I don't think any reasonable jury properly directed would come to any conclusion other than it was gratuitous sexual violence.
In November 2018, another former patient of Dr. Leakes went to police alleging that he had been shocked on the genitals. But he was told in an email by a detective, at this stage police will not be looking into those types of allegations. Following inquiries from New Sub Nation, the man was interviewed earlier this year, but has not yet heard whether or not Leeks will be charged.
There are some people in power that have made some very important decisions along this journey that need to be asked some serious questions about their decisions.
Questions that will be asked by the Royal Commission into Abuse and Care, which is now investigating Lake Alice.
This case is a disgrace. It's disgusting. Those children were abused 3 times. They were abused to lead them into having to be at Lake Alice. They have been abused and tortured in Lake Alice, and they are abused a 3rd time by the fact that the police and Crown lawyers who should have made the proper decision to prosecute on their behalf failed to do that. And the prosecution could still be brought, in my opinion.
Well, we were going to interview Justice Minister Andrew Little, but he pulled out on advice from his ministry and Crown Law. They said it would be inappropriate for him to comment on a case that will also be considered by the Royal Commission into Abuse in State Care. Meanwhile, Crown Law and the Ministry of Health have told us they would continue to cooperate with police if required. Well, the journalist who's behind that story has been investigating it for 3 years. Mike Wesley-Smith joins me now. Mike, thanks for your time. 3 years?
Yeah, I was looking, there's more than 2,000 emails I've sent over that time trying to get to the truth on this. I'll just point out at this stage, the Crown and Ministry of Health acknowledge that these patients were subjected to unacceptable treatment. They point out that there's been a settlement, there's been an apology. Also, we tried to contact Malcolm Burgess for that story without success. But yeah, it has been a long road to this point and we still don't know the full picture.
Right, and the key players who haven't fronted up are who?
We've approached government ministers, the police, the New Zealand Medical Council, the Royal College, Crown Law. None of them wanted to be interviewed. They instead sent us some statements, the full contents of which we'll put online. But yeah, to me, I was surprised after all of this time and a case of this magnitude. We are talking about 200 alleged acts of cruel and degrading treatment and possibly torture.
And that's why this is so crucial, isn't it?
Yeah, absolutely. I mean, I think, these people, we can't give them their youth back. But what we can do is we can give them the truth of what happened to them. And basically what their message to decision makers is, put down your budget analysis, put down the advice you've been getting from Crown Law, and just be guided by the instinct that should exist in all of us, which is ask yourself that question, if this was my 8-year-old, if this was my 9-year-old, what would I want to have happen to them?
So do you think that these government departments or these institutions are looking through the lens of just, a political and budgetary lens, or a legal lens, not through a human lens?
Part of the problem is we don't really know. I mean, much of this material is covered by legal privilege. These patients, I can tell you what they don't want. They don't want blacked out documents. They don't want people claiming legal privilege. They don't want delays. They just want someone in government to look like they give a damn about what happened to them. And, the apology they got some years ago, they see that as a conditional apology. It was phrased as without admission of liability. Well, every expert that I've spoken to in the psychiatric profession, the legal profession, law enforcement, I haven't been able to find somebody that can tell me this is legally defensible.
Okay. So what should the government do to put things right?
Well, there's a case by a patient brought before the United Nations with the assistance of a patient rights group called the Citizen Commission on Human Rights. They will be asking some questions. One thing that we've noticed, the most recent submissions the government made to the United Nations does not include reference to the fact that for almost a decade, the government was co-defendants with Leeks in civil proceedings. That's a material fact that doesn't form part of their submissions. We've asked them why that was not included. They have not told us. So I think really the appeal from the patients is just please just tell the truth, the whole truth, and nothing but the truth.
So if they're taking their case back to the United Nations, what can the United Nations do if they do find against the New Zealand government?
So complaints of this kind for New Zealand are exceedingly rare. In fact, this may be the first one, I'm told by an expert. The committee can't award compensation. But what they can do is they can make a finding that if they believe the investigation has been inadequate, then that is a real, that's a public statement, particularly from the United Nations, of some significance.
Right.
And that, I don't think the government would treat such a finding lightly. And I think the patients will hope that they will now, just be a bit more of full disclosure to the United Nations.
So this has been going on for so long, and yet it's unfolding yet again next week. Is it? What's happening? Is it next week that this UN is considering this?
So we just have a time window. We don't have a specific date. We've been told that the case comes back before the Committee Against Torture sometime before the 6th of December. So hopefully, maybe that's an avenue through which some of these patients who've been waiting 40 years. Remember, they were kids when this happened to them. Many of them are approaching retirement age. They just want to know what happened to them.
The United Nations has found New Zealand breached the Convention Against Torture by failing to properly investigate abuse at Lake Alice Hospital in the 1970s. A victim took the case to the UN because the psychiatrist accused of electrocuting patients as punishment has never faced charges. News Hub Nation's Mike Wesley-Smith has this exclusive report.
It's a decision Paul Zentveld's waited a lifetime for.
This is a victory for the little people and the survivors.
A United Nations judgment that authorities failed to properly investigate the treatment of children like Paul at Lake Alice Hospital in Manawatu. Paul says in 1974 he was diagnosed with a behavioural disorder by psychiatrist Selwyn Leeks, who he claims then tortured him.
They have you sitting in the chair or they have you laying on the bed. Nurse is holding you down, you've got no choice.
Repeated attempts to contact Leeks, who now lives in Australia, have been unsuccessful, but he's always denied wrongdoing.
Do you apologise for anything?
No, I don't think I do.
Paul and 194 former patients received a government apology and compensation in the 2000s. But police decided there was insufficient evidence to prosecute.
No matter what the government officials say, torture on the testicles is pretty serious.
The police decision has now been criticised by the United Nations Committee Against Torture. In its judgment, the committee expressed concern authorities made insufficient efforts to establish what happened to children at Lake Alice. Therefore, ruled New Zealand had violated its obligations to properly investigate Paul's claims of torture and had endorsed actions leading to impunity for Dr. Leeks. The government and police are still considering the findings, but detectives have already reopened their investigation into Paul's case. Meanwhile, the Royal Commission into State Abuse says it will use its extensive powers to examine the police and government response to Paul. And evidence is building as other former patients have come forward with similar allegations against Leeks.
He applied shock treatment to my genitals, left with permanent burn marks on the underside of my penis.
It sparked and I got a burn on the end of my penis.
The UN has urged a prompt investigation into all of Paul's allegations and prosecutions where appropriate.
Oh, it's just another victory of people telling the truth.
Mike Wesley-Smith, News Hub.
About New Zealand being found guilty of torture. Twice now. There's not just Paul, there's also Malcolm as well. He's currently going through the same process. And it looks like there's going to be a few more coming that way too. And not just for torture. Now, the people that are, or the families, and they are 99% traumatised people that have ended up this way because of what the government has done. Something as simple as, say, a partner yelling at the dog to shut up can be misconstrued by a neighbour, incur a phone call to Child, Youth and Family, or Orangutan Mariki, and the next thing you know, Orangutan Mariki shows up on the doorstep and uplifts the children because there's reports of abuse. See, in family court, you don't need evidence. No, you can just have a unfounded, full of lies affidavit written by someone that hasn't spent any time or any, inkling of what goes on, and that's accepted as fact, and off they go. Hearsay is admissible in family courts, which is just fucking ridiculous. Now, if a child's uplifted, it should only ever be on a temporary basis, because the whole point is to try and fix the family, not destroy it. But anyway, I've had a lot of people asking for help since we've started the Family for Justice postings up on my channel, and as far as help, we can just sort of point people in whichever direction they need to be, but 99%, like I say again, it even becomes quite traumatising to myself and Steve, having to deal with these people that are, through no fault of their own, broken and it's very, very sad. I'm one of the rare ones that actually still has my children, so you know, I haven't gone through the same hell. Orangutan Mariki tried with me, but given it's a voluntary service that you can ask them to fuck off at any time, they were told that from day one. Didn't stop them sitting at the lounge table with my wife for over 2 hours trying to push her into saying something like he hit you, he pushed you, and all she could say was, no, he's looked after me in the wheelchair, he does all the cooking, he looks after the kids, he's fantastic. That really fucked them off. Okay, so yeah, when they showed up on my doorstep, I rang the managers and told them they're not welcome back, and we never ever saw them again. So I guess I was just one of the lucky ones. Unfortunately though, and it doesn't matter what ethnicity you are, whether you're Maori, Samoan, Indian, Pākehā, white, it doesn't matter. They are indiscriminate as to how many. I've currently got some Official Information Act requests in to Orangutan Mariki and Ministry of Health, Treasury, wanting to know prices as far as Lake Alice is concerned, and also asking them, because they all seem to be focusing solely on the Maori children that are uplifting. It's another ploy of divide and conquer, keep them all fighting amongst themselves, and that way they won't unite and realise what we're doing. So yeah, I've actually asked for full information from them as to how many children in total are uplifted each week, not just the 3 each week of Maoris, because New Zealand is a melting pot, people. There are lots and lots of mixed and diverse cultures in New Zealand, and we all seem to get along all right, or at least those with their heads screwed on right do. So what I'm going to do is I am going to read out, and this is from the United Nations Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment. This is an advanced unedited version, so I'm sure there's a final version to come out. New Zealand has had 3 months since the 6th of December to sort something out. As far as I'm aware, police are now reopening an investigation, so things may be happening, or it may be just another, you know, we'll keep them at bay and tell them we're working on it and never get anywhere, because this has happened 40 years ago. And a lot of people will say, you know, why are they waiting until they're middle-aged to talk about it? On November the 7th last year, at the Abuse and Care Royal Commission of Inquiry, Judge Andrew Beecroft, while giving his testimony, stated that it is on average through an Australian study that people take around 22.9 years to actually come to terms with what's happened to them to be able to speak out and talk about it. It is very, very rare for that to happen straight away.
Frankly, I think everything I have seen in my various roles is that we should be wary of trusting government agencies to design complaint systems. That's the frank reality. Let's go back to that complaints point, because I think there's one point that I just need to stress. There has been in one sense, understandable, if not commendable, determination to design a new complaint system through an adult eye, as if having a Rolls-Royce complaint system internally is going to solve it. Even externally, it may not solve it, because the real question is, unless you get a complaint to investigate, it doesn't matter much. We've got to be thinking about how do we create environments and systems that enable our most vulnerable children and young people, often detained in a situation of power imbalance, to complain. And that is why the Australian Royal Commission says it's 22.9 years on average before complaints are made. We should be wanting 22.9 seconds before complaints are made. And somehow we have to get an environment where the complaints can be made. Great having a good system to carry out the investigation, but we've got to encourage the complaints to be made at the time.
Which even makes it worse. Orangutan Mariki's had 30 years to get their shit right. And again, according to Judge Andrew Beecroft, if he had the option, he would bulldoze the whole lot of it tomorrow. So, you know, that's his words, and unfortunately those types of people like to talk much and do fuck all. I'm a firm believer in doing what you say you're going to do and taking it from there. Anyway, so this is the findings from the United Nations against New Zealand for cruel and inhuman torture or treatment to the kids. And children as young as 4 years old were being electrocuted on their genitals by Dr. Leeds. So, yeah, really shocking stuff. Shit. Let's put it up there on the screen so you can all watch it. Okay, so it says Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, Advanced Unedited Version, Committee Against Torture, decision adopted by the Committee under Article 22 of the Convention concerning communication number 852/2017 ... So they haven't given the full number, but that's alright. It's under CAT/C/68/D/852/2017. District is General, 27th of December 2019, and this is the original English written document. Okay, submitted by Paul Zentveld. Now, Paul's already been on the news. He was the guy that said, I don't know, I consider being electrocuted on the testicles quite serious. You know, it's nothing of this horrible treatment that happened to well over 88 patients should have happened. This sick, sadistic bastard that's now living over in Australia needs to be found accountable for what he's done. So it's submitted by Paul Zentveld, represented by Counsel Victor Boyd from Citizens Commission on Human Rights New Zealand, CCHR. They're doing a brilliant job. And the fact that none of them are lawyers and they still managed to pull this off is something to be said. Perhaps if you get a lawyer, you'll never get to pull this off. Why? Well, the lawyer's first duty is to the court. It's not to you. I've confirmed that many years ago by speaking to the New Zealand Law Society and having them tell me that. So, alleged victim is the complainant, state party is New Zealand, date of complaint was the 10th of July 2017 was the initial submission, so it's taken 2 years, or 2.5 years. Document references is decision taken pursuant to Rule 114 and 115 of the Committee's Rules of Procedure, transmitted to the state party on 20 of November 2017, not issued in document form. Alright, so it was transmitted, it was sent via email. And they're using pursuant to Rules 114 and 115 of the Committee's rules. So that's a good place to go start looking if you want to do something similar. Date of present decision is the 4th of December 2019, just like Mike Wesley Smith said on his TV report there. They had until the 6th of December, so they found this 2 days earlier. Subject matter is abuse of children in a state hospital, namely Lake Alice. Procedural issues, admissibility, rationale temporis, exhaustion of domestic remedies, which means they tried everything in New Zealand to get some sort of justice. The police weren't interested, you know, another standard cover-up, but we won't go there. This happens daily, and now, unfortunately, due to a case that was just decided this week by Judge Bell, High Court judge. He's an associate judge who appeared all morning to be for the complainants to allow the case to go through. At lunchtime, he came back and did a complete 180. And basically, as part of the decision, it's now been found that New Zealand police do not actually have to adhere to the principles of natural justice. So that's a shocker, and that's now set in case law. So that's really disgusting and scary stuff. But I'm going to be interviewing the lady behind all of that, hopefully in the next few months, and we'll get something together so all of you can be informed. It really is disgusting what happened in that case. If you want to know some background on it, I suggest going to New Zealand Justice 111 or NZ Justice 111 on YouTube. Have a look at everything that's up there, and there is anonymity used on that channel. As to now though, I don't think the person that runs that channel is too worried about that anymore and is happy to come out and put a face behind it. So again, in the next few months, hopefully we can get something sorted. Right, procedural issues. Substantive issue is lack of prompt and impartial investigation. Given that the police only spoke to 52 staff members at Lake Alice and only one of the over 50 people that had written affidavits and complained. Articles of the convention behind this are Articles 2, 10, 11, 12, 13 and 14. As far as orangutan Ricky's concerned, you need to be looking at Article 17 of the ICCPR, which is the International Covenant of Civil and Political Rights, where it basically says they're not allowed to stick their nose into family business. But yeah, you guys do your own research. I'm giving you the places to go look, and if you've got a good solid brain on your shoulders, in your head there, then it's not going to be a problem. You're going to understand what's going on. Okay, page 1. Oh, sorry, that was the cover page. Now we're on to page 2, and there's 16 pages here, guys, so it's going to be a bit of a read for you. 1. The complainant is Paul Zentveld, a national of New Zealand. Born in 1960, he claims a violation of his rights under Articles 2, 10, 11, 12 and 13 of the Convention. The State Party has made a declaration pursuant to Article 22, subsection 1 of the Government, effective from 10 December 1989. The complainant is represented by counsel. Facts as presented by the complainant. 2.1. The Child and Adolescent Unit at Lake Alice Hospital, a facility within the Government Department of Health, operated from 1972 to 1977 under psychiatrist Dr. Selwyn Leeks. The complainant was first admitted to Lake Alice in 1974 when he was 13. He was sent to the hospital by his mother, who considered that she had lost control over him. He was diagnosed with a behavioural disorder. His treatment consisted of administration of electric shocks, unmodified electroconvulsive therapy or ECT, drugs and solitary confinement on the grounds of bad behaviour and adopting a threatening attitude. He was admitted to Lake Alice 5 times for a total period of 2 years and 10 months. 2.2. In 1976 and 1977, a number of complaints were made by the government, or were made to the government, should I say, and medical organisations about treatment using an electric shock machine on children on various parts of their bodies, and drugs delivered as a punishment and not for therapeutic purposes. The complaints did not result in any prosecutions. Isn't that shocking? The psychiatrist who was running the unit left New Zealand to work in Melbourne, Australia. 2.3. Much later, in 1997, 20 years later, several articles were published in the media in New Zealand and later in Australia on the abuse that had occurred to children of Lake Alice. Thereafter, former patients started coming forward in 1999. A civil claim was filed before the Wellington High Court on behalf of 56 former patients. This number increased to 85 by 2001. When the government compensated these victims with a $6 million New Zealand dollar payment and a letter of apology, and I'm just going to pause right there and say, in that first section, the lawyers took 40% of that $6 million compensation, so therefore we'll say 6 million, half that's 3 million, so 4 million actually got divided between those 56 people, alright, which isn't a lot, and the lawyers took almost half of it. Just like to point that out. other 110 claimants came forward by 2009, including the complainant. At the government's invitation to provide further compensation, all of the claims of ill treatment and abuse were dealt with by the way of a general apology and ex gratia payments to each individual. In total, 12.8 million New Zealand dollars was paid out by the government to 195 victims. Now take 40% off of that, people, and then divide that by 195. It's not a lot. I'll try and put the math up for you. Here. Alright. 2.4. In 1999, the Medical Council allowed cancellation of Dr. Leeks' medical practicing registration. The council stated that Dr. Leeks was no longer registered with the council. Allegations of ill treatment would not be investigated by them. So they ditched his registration and then went, not our problem. Pass the buck. Great way to wipe any, sort of liability from them, isn't it? Okay. 2.5, and there's subtext down the bottom, which I'm not going to get into, but if you guys want to read it, I will drop a link to this in PDF form in the description, so anybody can download it and read it. 2.5. In 2001, retired High Court Judge Sir Rodney Gallen was commissioned by the government to review the complaints concerning Lake Alice. Sir Rodney found that the administration of unmodified ECT was not only common at Lake Alice but routine, and that it was administered not as therapy but as a punishment. He also found that many of the children admitted to the hospital were not mentally ill. 2.6. In 2003, the complainant filed a complaint with the Medical Practitioners Board of Victoria in Australia, as Dr. Leeks was practicing there since he left New Zealand in early 1978. In 2006, the board prepared a formal hearing under the Medical Practice Act 1994. They had 39 allegations against Dr. Leeks of infamous conduct in a professional setting when practicing at Lake Alice in the 1970s. The complainant was set to fly to Australia and give evidence, but on the eve of the data set for formal hearing, 19th of July 2006, Dr. Leeks resigned all forms of practice. The board accepted this after therefore the hearing never took place, as it considered that it had no jurisdiction over a resigned practitioner. So this is how he gets away with it. He just resigns, and then the board that oversees him has no power over him. Where are we up to? In 2011, the Australian Health Practitioner Regulation Agency stated that the community was protected from all forms of Dr. Leeks' Lake Alice conduct, and that the outcome was the same as if a complaint against Dr. Leeks had been successful. Really. 2.7. Also in 2003, following the government invitation to former Lake Alice victims who had received an apology to make a criminal complaint to the police, the Citizens Commission on Human Rights submitted several complaints to the police in 2006. The complainant himself submitted his case to the police, alleging criminal conduct by former Lake Alice staff, including Dr. Leeks, but not only him. Alright, there's the nurses and stuff that helped and went along with this. Some nurses were against it, but there were other staff that helped. They need to be held accountable too. Police investigation on complainants and other victims' complaints was initially focused on possible violations of the Mental Health Act 1969. Police explained that the Act was the correct legal framework to examine the complaints, but mentioned that part of the law required complaints of this type to be made within 6 months of the alleged incidents. It's the old statute of limitations kicking in. Therefore, in 2010, police closed its investigation with the argument that they could not mount a criminal prosecution given the passage of time. Since the events took place, the unavailability of witnesses and the likelihood of a defence where there has already been investigations. 2.8. On 4 June 2009, the committee adopted concluding observations on New Zealand's 5th periodic report, as requested the state party to take appropriate measures to ensure the allegations of cruel, inhumane and degrading treatment in the historic cases are investigated promptly and impartially, perpetrators duly prosecuted and the victims accorded redress, including adequate compensation and rehabilitation. 2.9. In 2015, the complainant requested the police report of the investigation regarding his complaint of torture and ill treatment. This report included that the police considered that the treatment that the complaint received amounted to a crime. Despite this finding, the police held it was too late to prosecute, because in the Crimes Act there are also time limits, whether it's a Category 1, 2, 3, 4 offence. Category 1 offences like speeding tickets, for instance, which I've challenged and won, those are a Category 1 offence. They're usually a strict liability offence or a summary judgment, which is why the Summary Offences Act 1981 kicks in. The Summary Offences Act, in the schedules there, it basically states that the charging document, or the offence, needs to be filed within 6 months of the occurrence of the incident, and it must be dealt with in a prompt and timely manner and be over and done with within 12 months. The judge can extend that if so needed, but that's generally the time frame. Category 2, 3 and 4 offences, I'm sure, will be in one of the schedules somewhere around the Crimes Act 1961, but that's for you guys to go look up. I'm just spitballing off the top of my head. Okay, the complaint. 3.1. The complainant alleges that he was a victim of ill treatment and torture in the child and adolescent unit of Lake Alice Hospital. He complains that the state party has not ensured accountability for the staff at Lake Alice Hospital who abused and ill-treated children in their care. The state party's medical council accepted the resignation of Dr. Selwyn Leeks in 1999, thus claiming no jurisdiction over him. The Australian Medical Practitioners Board did the same when Dr. Leeks resigned from all practice in 2009. The day before they were to begin a hearing into his practice, the state party's police claimed they could not prosecute. Dr. Leeks, on the other Lake Alice, or the other Lake Alice staff, due to the statute of limitations, without any investigation, the alleged perpetrators received no disciplinary punishment, and the state party medical authorities did not denounce the actions of the former Lake Alice staff and the treatment of the victims. No official medical reviews of the practice at Lake Alice and no statement barring such practices have been released. 3.2. The complainant submits that the state party did not consider available avenues of formal investigation, such as the ministerial inquiry. Lake Alice was administered and staffed by government employees. A formal inquiry would be one possible way of achieving accountability for the ill treatment suffered. Another avenue of investigation would be to require medical authorities to investigate a former practitioner, even if said person resigns. Dr. Leeks would have faced serious disciplinary measures if he had to face the medical councils in either New Zealand or Australia. Terrible stuff. State parties' observations on admissibility and the merits. 4.1. On 18th of May 2018, the state party submitted observations. In the first notes that the only aspect of the complaint which is not inadmissible, rationale temporis, is that the alleged main perpetrator of the abuse at Lake Alice Psychiatric Hospital, Dr. Selwyn Leeks, has not been held to account for his actions. However, the complainant claims against Dr. Leeks have been investigated and reviewed by the police. Like fuck they have. The decision not to prosecute Dr. Leakes was informed by a lack of evidence to support a prosecution and the determination that was made following on from previous police investigations of similar complaints and contemporaneous examination of complaints by police. A commission of inquiry and chief ombudsman in the 1970s in these circumstances. Not prosecuting Dr. Leakes is not a breach of the state's party's obligations under the convention. It is now too late for a prosecution to be undertaken, and there would be valid concerns for the maintenance of fair trials rights. 4.2. The state party took action in the 2000s to consider the claims of former patients and to compensate and apologise to them for what they had experienced, including the complainant. Moreover, the extensive reform of the legislative regime of the rights of patients in general and of the use of electroconvulsive treatment in particular means that similar events are exceedingly unlikely to occur again. If there is anything further to be explored in the relation to the treatment of children and adolescents in Child and Adolescent Unit, then this may be achieved by the Royal Commission of Inquiry into Historical Abuse and State Care announced in February 2018, which I have broken down all 2 weeks of 8 hours worth of testimonies each day, and I've broken them down into 28 individual testimonies of these people. They're all between half an hour to sometimes up to 2 hours long, so if you guys want to go and watch them, I have a playlist called the Royal Commission of Inquiry into Abuse and Care, or just go and search for Abuse and Care on my channel. All of them are there, all 28, along with the clips that have been put on national television so far. So they're all out there in public view. So if you want to go watch them, go have at it. Again, I can probably put the links in the description for you. Now, where are we? 4.3. Complaints began to emerge in or around 1976 to 1997 concerning the Child and Adolescent Unit at Lake Alice Psychiatric Hospital, a 1977 Commission of Inquiry to investigate the treatment of adolescents of an adolescent boy who had been a patient in 1975 and 76. A 1977 report of an investigation by the Ombudsman regarding a boy's treatment between 1973 and 76. A 1977 complaint to the Hospital Inspectorate about treatment of 2 patients in 1974, a 1977 complaint to the Mental Health Authorities about a boy's ECT treatment, a 1991 complaint of a former patient to the Medical Practitioners Disciplinary Committee, 2006 disciplinary proceedings against Dr. Leakes in Victoria, Australia, and the complainant's 2010 complaint to the Medical Council of New Zealand about Dr. Leakes. 4.4. Following the settlement of the Lake Alice class action, the government offered compensation and apologised to the litigants, including the complainant. The complainant also had the opportunity to attend a confidential listening and assistance service. It is not known whether he took this opportunity. This service was established by the government in 2008 to provide a confidential and supportive forum for people who had experienced abuse or neglect during their time in state care, in residential, special education, health and welfare sectors before 1992. This service is now discontinued. 4.5. The state party then refers to the complaints to the police in the 2000s. Thus, in 2002, several former patients involved in civil proceeding complained to the police. 2 further complaints followed in 2006, including ones by the complainant on 21st of April 2006. Complaints referred to the applicant of electric shocks and the administration of drugs as punishment, and also alleged instances of sexual offending. 4.6. The police took a number of steps to investigate the complainant's allegations and see if further inquiry was warranted. It made contact with the person who represented most of the claimants in the civil actions and obtained the files relating to those whose complaints had been referred to the police. It received additional files from the other complainants or through intermediaries. Searches were undertaken to locate early complaints. Medical records, where available, were obtained. Inquiries were carried out with some of the staff identified by the patients, and their statements recorded. Some of the key statements made earlier by the staff witnesses were obtained, and expert opinions regarding the use of ECT to children was obtained. The former Lake Alice Psychiatric Hospital site was photographed and the site plans obtained, and the complainant's statement were analysed against the available medical notes. The police found evidence of the application of ECT in both treatment modes and the application of electric shocks in circumstances that might suggest use as a form of aversion therapy or punishment. In the exercise of its prosecutorial decision, the police considered the legal position regarding the alleged offences. 4.7. The care and treatment of patients suffering mental illness in the 1970s were subject to the Mental Health Act 1969. Section 112 contains an offence of ill-treating a person with a mental disorder. While this would have been the appropriate charge for police to consider on the facts, a 6-month time limit for commencing proceedings had long expired. How ridiculous. Someone who's been electrocuted as a form of punishment, who's had their head completely mangled up, have got to make a complaint within 6 months? They probably don't even have a clue what's going on or what day it is within 6 months of that happening, and took years of therapy to overcome what was done to them. So that is ridiculous to have a 6-month time limit. Oh my fucking God. A charge against Dr. Leeks under that act was therefore time barred. Isn't he lucky? 4.8. The police then considered the Crimes Act 1961 in accordance to Section 195. Anyone who having custody, control or charge of a child under the age of 16 willfully ill-treats the child in a manner likely to cause them unnecessary suffering, actually bodily harm, injuring to health or any mental health disorder or disability is liable to a term of imprisonment not exceeding 5 years. That's a bit light, isn't it? However, police determined there was unlikely to be sufficient evidence to successfully prosecute a charge of willfully cruelty to a child against Dr. Leeks. Are you kidding me? It considered that several potential witnesses were dead. The rest of them aren't, and they only spoke to one victim of 195 that were paid out from those compensations. So they spoke to one victim. If you call that a sufficient investigation, or even an impartial or unbiased investigation, you need your head read. It considered that several potential witnesses were dead. One of the nurses interviewed had the onset of dementia. One. What about the other 51 that they interviewed? It considered that several potential witnesses were dead. The onset of dementia. Most of the former nursing staff were in their 60s or 70s. So what? Does that mean they don't have a tongue in their head? Or a brain? Or memory? And Dr. Leeks himself was a resident in Australia, and by then an Australian citizen. The police also considered relevant that the police investigation of the complaint brought by the complainant was the 7th examination by New Zealand agencies of these related facts since 1977. So fucking what? If it was the 77th or 777th, that means that shit's not getting done properly. Get it right the first time, and the other 6 might not have had to happen. Again, not doing your job right. Over 30 years had elapsed since the alleged offending. Issues of abuse of process were noted, although not considered. It's just sad. 4.9. In or around December 2009, police reached a final view that there was no realistic prospect that a criminal prosecution would be successful against Dr. Leakes, and having regard to guidelines for prosecution published by the Solicitor General, there was no countervailing public interest in proceeding with a prosecution, apart from the 195 people that were paid out compensation. I mean, they weren't members of the public. I'm sure they didn't have any interest at all, did they, New Zealand Police? Perhaps if it was actually made public to everybody, there may have been more public interest. Do you just think about that? You know, there might be a 2 or 3 minute bit on a news story somewhere, but this was all buried. So, wonder why there wasn't any public interest. Perhaps nobody fucking knew about it. 4.9. In or around December 2009, police reached a final view that was no realistic prospect that the criminal prosecution would be successful against Dr. Leakes, and having regard to the guidelines for prosecution published by the Solicitor General, there was no countervailing public interest in proceeding with a prosecution. Unfucking believable. The complainant was advised by letter dated 15th of March 2010 of the outcome of the investigation. 4.10. The State Party considered that the communication is inadmissible on several grounds. The Convention entered into force for the State Party on 9 January 1990, insofar as it seeks to impugn the actions of the State Party prior to that date. The communication is inadmissible, rationale temporis. Allegations of breach of Articles 2, 10 and 11 may therefore be set aside. Oh yeah, but let's not forget about the other articles, shall we? 4.12. Then the complainant had not exhausted all available domestic remedies. He has not reviewed the decisions of the Medical Council of New Zealand. The Medical Council's decision not to investigate Dr. Leakes cannot be attributed to the government because the Council is an independent regulatory body. There's old arm's length from the government type shit, eh? But while the Council determines not to prosecute Dr. Leakes, it has always been the case that decisions of the Council may be challenged in the higher courts. Neither the complainant nor others sought at that relevant time to judicially review the decisions of the Convention not to investigate Dr. Leakes. It remains a possibility that such review may well have been successful, but now, given the lapse of time, the complainant would be unlikely to obtain a substantive remedy in any judicial review proceedings. Sounds like an exhausted remedy to me. 4.13. Also, the complainant is likely to have the opportunity to participate in the Royal Commission into Historical Abuse and State Care. Yeah, he did have that opportunity. He didn't give testimony though. I think the other 20 odd people that gave testimony was sufficient, but there are written affidavits and not just the spoken testimonials that were held during that public inquiry. The communication predates the announcement of the Royal Commission and has not taken this into consideration. Although the government has yet to make a final decision on the terms of reference, the indications are that the state care to be examined will include child welfare and the youth justice placements, as well as care in psychiatric hospitals. It follows that there is a strong likelihood the Royal Commission will consider the claims of the former patients of the Child and Adolescent Unit. However, the State Party acknowledges that the Royal Commission aims to form policy going forward and has no powers to determine the civil, criminal or disciplinary liability of any person. Okay, so they'll have the findings and they'll try and make some legislation to help and stuff, but they have no jurisdiction as far as civil or criminal or disciplinary proceedings. So what they find has no bearing in him getting any redress for what he's been wronged for. Okay? This means that the inquiry will not necessarily undertake the sort of forensic inquiry that might have been expected in a criminal prosecution. Conversely, it also means that the Royal Commission does not give rise to the fair trial concerns which would accompany any decision to prosecute Dr. Leakes. 4.14. Finally, the time elapsed since the events, the old time-lapse thing again, and the complainant's purported exhaustion of his domestic remedies, which is resisted, is unreasonably prolonged so as to render consideration to the claims and relief sought by the complainant unduly difficult by the state party. On the 15th of March 2010, just 9 years before that big shoot-up, the complainant was informed by the police that it would not be prosecuting Dr. Leakes, but he lodged his complaint with the committee on the 30th of October 2017 without explaining the delay, in conjunction with the fact that the events invoked occurred over 40 years ago. Any consideration of the complaint's claims, insofar as they relate to the criminal culpability of Dr. Leakes by the government, is now unduly difficult. Well, whose fault's that? There would also be valid concerns for the maintenance of fair trial rights for all parties involved if a criminal prosecution were to be attempted now. So they're worried about Dr. Leakes having a fair trial. Needless to say, it's because he resigned from both of those places that they had no jurisdiction, so there was no fucking way they could do anything. That's how he countered the complaints. Alright? And then you start using the time problems or the time limits on criminality. So that needs to be looked at, doesn't it? Wonder if the Royal Commission's going to extend the time for that type of offence. Or is it going to create some new ones, perhaps? We will see. That still is out. 4.15. On the merits, the state party first submits that the documents communicated to the committee furnish no proof that the government has failed to discharge its obligations under Article 10. The events occurred between 1972 and 77, and the complainant had not raised any issues of insufficient education and information of personnel during the relevant post-ratification period. Therefore, Article 10 is not engaged. 4.16. Then, the state party acknowledges that the compliance with Article 11 is a step it can take to ensure it complies with its Article 2 obligations. Even if Article 11 is relevant for the pre-ratification period, which is resisted, in other words they object to it, the state party submits there was comprehensive compliance in the 1970s with the requirement to take effective legislative, administrative, judicial or other measures to prevent acts of torture, Article 2, or to review instructions, methods and practices as well as arrangements for the custody and treatment of persons who are detained, Article 11. These early reviews by the relevant state agencies are significant because they occurred at the same time as or close in time to the operation of Child and Adolescent Unit. Their examination of the relevant issues was thorough, the Commission of Inquiry and the Ombudsman having the ability to call and receive evidence, and no prosecutorial outcomes followed these investigations, because the police kiboshed doing it. 4.17. In regards to the post-ratification period, the documents communicated to the committee furnished no proof that the state party has failed to discharge its obligations under Articles 2 and 11, either considering Article 11 on its own or in conjunction with Article 2. In the 2000s, when further complaints emerged, the state party acted responsibly to consider the allegations and to compensate and apologise to the former patients, including the complainant. Although the settlement process was not a government inquiry per se, the settlement examined individual cases and avoided the needs for claimants to endure the stress and risk of a civil trial to establish their claims. There have also been substantial changes in medical practice since the operation of the Child and Adolescent Unit. Medical professionals operate now within a very different regulatory framework. As a result, the events at Lake Alice Psychiatric Hospital are very unlikely to occur again in the state party. 4.18. Even if Articles 12 and 13 are relevant for the pre-ratification period, there was comprehensive compliance with these articles. Investigations in the 1970s of allegations concerning Lake Alice Psychiatric Hospital were timely and conducted in a prompt and impartial manner in accordance with Articles 12 and 13. As regards to the post-ratification period, it was without contest that the complainant had exercised his right to complain to the police. The state party interpreted the complaint to be alleged in the main that Article 12 had been breached because police did not prosecute Dr. Leakes. The government has not held a ministerial inquiry into the events at Lake Alice, and the Medical Council decision not to investigate Dr. Leakes because he was no longer a member of the New Zealand medical profession was inadequate. 4.19. Numerous investigations have been undertaken by the police starting in the 1970s and more recently in the 2000s. Those investigations have sought to determine both the nature and circumstances of the alleged criminal offending at Lake Alice Psychiatric Hospital, and to establish the identity of any person who may have been involved therein. The central question which arises in the present communications is whether the decision of the police not to prosecute Dr. Leakes was a breach of either Articles 12 or 13. The state party submits it was not. 4.20. Article 12 does not oblige state parties to prosecute an individual accused of torture in circumstances where there is insufficient evidence for a prosecution to succeed. The Article 12 obligation imposed a duty on state parties to investigate torture when it had reasonable grounds to do so. The police investigated and determined not to prosecute Dr. Leakes because of lack of sufficient evidence and a determination that the public interest did not merit prosecution. Did they ask the public? These decisions were taken and reviewed by senior members of the police. So they're under the take more then. The decision is not inconsistent with either Article 12 or 13, as has been recognised by leading commentators. The International Court of Justice has also considered that the obligations to submit a case to the competent authorities under Article 7.1 of the Convention may or may not result in the institution of proceedings. In the light of the evidence before them, moreover, given the length of time which elapsed since the acts which constitute alleged torture, and the resulting unavailability of witnesses, there is real prospect that Dr. Leakes' right to a fair trial and the rights of any former staff members would be infringed if there was to be a criminal prosecution now. 4.21. As to the state party's decision not to hold a ministerial inquiry, the Convention does not include the obligation to hold an inquiry of that nature. It only requires a competent state authority to investigate the alleged torture which has happened. In any event, government inquiries cannot determine the civil, criminal or disciplinary liability of any person, but are directed at establishing the facts which occurred in relation to a certain event, with a view to informing policies development in the future. The state party recalls that it has in fact decided to hold a Royal Commission of Inquiry into historical abuse in state care, and that the events underpinned the complainant's claim may well be considered by that commission. Well, his claim may well be, but any criminality about Dr. Leakes isn't going to be. 4.22. As to the complainants alleging that the Medical Council should have investigated Dr. Leakes, The state party refers to its argument on admissibility that, on the one hand, the council is a body independent from the government, hence its decision cannot be attributed to the government, and, on the other hand, aggrieved claimants, including the complainant, retained the right at the time to seek review of that decision in a higher court, but they chose not to exercise that right. 4.23. Finally, the state party refers to steps it has taken to change the medical practice so that the events at Lake Alice Psychiatric Hospital are very unlikely to occur again. Oh great, so they're admitting it occurred in the first place then. It's not that they don't believe them, it's just that there's no evidence. And yet they've made changes to the other hospitals and psychiatric care since. Well, why make changes if they think that there's nothing behind it? I mean, you've got to wonder about that. It's kind of like painting over white lines after saying there's no fault with the markings. Auckland Council, Auckland Transport. I mean, why paint over those white lines that are misleading road users if there's nothing wrong with them and you're okay to issue a ticket? Which I proved and set case law that you kind of have to fix it. That you can't use misleading markings. So it's the exact same stuff. That they've it really does do your head in. That they've made changes to make sure nothing like the happened at Lake Alice ever happens again. So by making the changes, they're admitting it happened, and they've compensated people, but in the same breath, there's not enough evidence. There's only 195 complainants that got paid out, but there's not enough evidence for the police to prosecute him, even if the time limit was quashed and there was legislation all of a sudden saying historic abuses may be brought in criminal proceedings. How about doing something like that? Wouldn't that work? But no. I like to try and lighten the mood a bit, because this shit just gets to you. I mean, how fucking disgusting. Okay? So that's the state's response. Right, I'm going to pause it here, and I'll make a part 2. Basically because I don't want these clips to be too long. So jump on to part 2 if you want to continue listening to me reading this. I will do my best to edit out any misspoken bits or any things I had to repeat. So I will do my best, as I'm sure you guys know I do. Alright, so see you in part 2. I'll be back real soon. Watch this space.